let us look at the issue of the recently delivered judgment, of course, which so many legal scholars have described as a landmark decision, in the history of the nation. So, Barrister Obiorome, what do you have to say concerning that judgment?
I agree entirely. That's a landmark judgment. It's a decision that will go a long way into making it clear that we are getting closer to constitutional democracy. Before now, we know that our constitution clearly provides for local government council that must be elected democratically. But over time, we have seen instances where governors dissolve elected local government council chairmen and then put in place caretaker committees. And those caretaker committees now run their affairs to local government contrary to the clear provisions of the Constitution. And of course, we know that the Constitution is supreme, is the ground norm, the overriding law of this country. And like it's always said, that any law that conflicts with the Constitution is null and void. Now, with the judgment of Supreme Court, something is so gladdening that henceforth, in compliance with the provision of Section 162, subsection 3 of the 1999 Constitution, the monies in the Federation account shall be divided into three. One portion goes to the federal government, the other one goes to the state government, and the one for the local government goes directly to the local government. Now, the issue of joint account between the governors, the state government, and the local council has now been abolished, because in line with the pronouncement of the Supreme Court on the issue of how the money is dispersed, the Supreme Court said that the money spent for the local government council must be sent directly to the local government council, and any state where the local government councils do not have elected officers, no money should be sent to that place. And we now are witnessing a situation where at the grassroots there will be meaningful democratic practices, because the projects that at the local government are supposed to be handled, which have been abandoned over time, will now be handled by local government council. Of course, we know that in the Constitution there are duties assigned to local government councils, which over time have been in abeyance. So with this landmark judgment, which is a victory for democracy, it's a victory to rule of law, because now the Constitution is being allowed to prevail. It's a right thing in the right direction.
Well, we'll come back to you on that, because you did mention in your analysis about the joint account between, of course, which I feel is constitutional, but now that this judgment, but we'll come back to that.
Yes.
But Barrister Deji, what do you have to say?
Well, I want to agree with those who feel that this judgment is a landmark judgment, except of course that there is a little rider to it. The question of the implementation and enforcement of this judgment is another thing. Because if you look at it, some will say it's not yet uhuru, in the sense that in almost all our states, the governor is the one that determines who is elected as the local government chairman. And not only that, the processes for the election of the local government council itself is completely in the hands of the governor. The governor appoints the State Electoral Commission that deals with this appointment of this local government chairman. So to that extent, yes, the money can be disbursed, but you discover that most of the local government still operate as if they are appendages and rookies of the governor. We have had situation like in my own state where a complaint was made almost on a similar issue, Ogun State, where a complaint was made by a local government chairman, and the governor became very angry to the point that even he was threatening the local government council. All the chairmen of the state had to go to the governor to go and prostrate, to beg the governor to be able to allow the local government chairman to operate. I think we should be talking more of the independence of our local government system, more or less, than just the fiscal autonomy that we are seeing that is being played out by this judgment. Yes, the judgment had drawn a line or a threshold of control that the state can have vis-a-vis the local government. Now the fund can come directly from the federal government into the local government account. But you discover that creates a problem for section 162 subsection 5 of the constitution, which requires that the money that is standing to the credit of the local government from the federation's account should be paid to the governor, to the state. So that provision will now have to be amended by the National Assembly. And I think that's why those who are opposed to this judgment, that's the position they probably have in mind, because that section says that money standing to the credit of the state from the federation's account should be paid to the state. Mention specifically the state, except of course for subsection 8 of that section 162, which allows for any money that is standing to the credit of the council to be paid to the council. So it appears as if there is some bit of legal discrepancy around those provisions of the constitution vis-a-vis the judgment of the Supreme Court.
That needs to be considered.
And of course, the Supreme Court is the final court.
Okay, we will come back to that by today, but our Zoom guest is standing by. We need to bring him on online. Barrister Ajanaku is our Zoom guest. Yes. Okay. Yes. Welcome, Barrister Ajanaku. I don't know if you can hear me.
I can hear you. Good evening. Thank you for having me on. I can hear you clearly.
Okay. Okay. We are discussing the issue of the local government autonomy. Okay. So I'm sure you followed the judgment. Of course, so many people have expressed satisfaction that judgment is a landmark one, while some has expressed a little bit of misgiving concerning the judgment. Of course, some have argued that when it comes to a federal system, that we usually have two, the federal government and the federating unit, that the local government should be left to the control of the state government, that what we have now, having this financial autonomy, does not augur well for a true federalism. I don't know, what will you have to say concerning that?
Thank you very much. I listened to the guests in the studio, the two of them, and I want to first and foremost agree with what they said in respect of the judgment being a landmark one. That one is basic. But then, one is now looking at the constitutional provision in respect of this judgment. As we have it in the Constitution as amended in 2004, the misgivings that you have stated that some are having is that how will the local governments be allowed to work properly? Now they're having financial autonomy. But look at it. We have three tiers of government: the federal, the state, and the local government authorities. The local government is one that is closest to the people. Over time, what has happened, and as my learned friend there stated, in respect of the local government in Ogun State, in Ijebu-Ode precisely, where there was altercations between the local government chairperson and the governor himself. What did he demand for? Making money available to the local government to be able to function. And in the absence of money being available to function, when the person in charge of the local government is not someone that is close to the governor, they will be deprived of funds to function. That was why there was altercation between that governor and the local government chairman. Now, the Supreme Court has risen to this occasion by saying, well, yes, in fact and indeed, the governor or the state should not dictate what goes to the local government, because that has been the situation over time. Now, we're not having good development as we needed same to be because of starvation of funds. Do you understand, sir? But I am saying, sir, that as it were, the Supreme Court has done well. The entanglements that we have in Section 162 and the subparagraphs that we have therein will also be resolved when, by what Mr. Adedeji said, if the legislature look critically at the provisions of the law, particularly that section or subsection 5 of same, to make it in tandem with the yearnings of the people. The yearnings of the people
Okay, we lost our guest. We'll get him back, and we'll continue with this trend. Okay, here.
Hello, sir.
Yes, I can hear you.
I'm saying, sir, that with this current judgment, there will be development to the people and the local government area, and we'll be able to go on and move forward.
Also want to get your opinion on the issue concerning the fact that the federal government will have to be paying this money directly to democratically elected local government. What happens in a state where you have caretaker local government manning those states? Does it mean that the people of that locality will be deprived of their legitimate fund, which the Constitution has already allocated to them?
The Supreme Court is very clear. Can money be paid or made to a party or a body or an ad hoc committee to hold forth for a local government that is not democratically elected? The answer is no. They are saying if you want development in any local government, ensure that once their time is about to be due, elections are conducted, and the moment they are out of the current people are out of office, the new ones can come in immediately. So now the people are awake to their responsibility and to their rights. They will not make it. The people will rise up and ensure that once the term of an incumbent local government chairman expires, immediately an election will be held in that position to fill the vacancy. And who will do this? The people. The people will not just want to allow a vacuum in this instance, so that there can be development in their respective local government areas.
Some of the state governments are also listening. They want to understand. But the question is, would the federal government hold this fund in trust for those local government pending till when they will be elected? Or does it mean the Supreme Court judgment means that once you have caretaker, that money would not be remitted? I want to understand, because we know that we'll have about caretaker for so many states across the federation. And the conducting of election has to do with the state governor. They are the one that constitute the electoral commission for this local government. So when there is no elected local government, these monies that are meant for the people, doesn't mean that they will forfeit that money, or it will be held in trust for them till an elected local government is in place.
Unfortunately, the answer is yes. It will be held in trust. You know why? A typical example will be that one of when the president, when he was a governor between 1999 and 2007. You remember that there was an altercation, a rift between the government of Obasanjo, General Obasanjo retired then, and this president, Bola Tinubu, where when LCDA, local council development areas were brought up, the governments at the federal level refused to remit the sums payable to the local government or the entire local government areas in Lagos State. But the moment there was judgment and the court ordered that the federal government should remit the money payable to them, it was given to them. I also believe that in this wise, what will happen is not a different thing. When the federal government is unable to make the payments available to them from the federal allocation account, well, what will happen is that it will be held in trust. Nobody will ever use that money. The moment there is a local government in place, a properly elected local government chairperson, and with not one's ad hoc committees, all that, when those ones are back in place, the federal government will release the money upon demand for sale. That's my take.
All right, Mr. we'll come back to you on this. Let's just see get the view of our guests who are on the studio. So, of course, we're asking if, because we need to understand this judgment is a fresh judgment.
Yes.
And when you have a judgment, we need to understand the purpose, the grant of this, because when the judgment have said that the federal government has to pay directly to democratically elected local government.
Yes.
So the question is, when there is no elected local government, is it going to be held in trust and paid later on?
It is very clear that what the Constitution has created and provided for is democratically elected local government councils. And in line with that constitutional provision, the Supreme Court has said that in any state where there is no democratically elected local government council, no money should be paid to that local government. And that is in line with the constitutional provision in section 7. Now, to that extent, where there is in any state local government council that does not have elected officials but catered committees, the money meant for that council will be held in trust for that council until they put in place a democratically elected local government council.
So, for instance, if a governor refuses to conduct local government election for 3 years and he conducts 6 at the end of his during the end of his term, or maybe a year preceding his, then they will pay the 3 years to that local government. Is that what it means?
Now, you see, we are getting it clearer. Now, it is clear that what operates in Nigeria is federalism, where you have 3 tripartite levels of power: the federal government, the state government, and the local government. And if you look at section 162, which I made reference to earlier, subsection 3, it says that the money from the federal account can be divided into 3. A portion goes to the federal government, another portion to the state government, and the last portion to the local government. It did not say that some will go to states to hold for the local government, which is what has been happening before now. And I see personally that there are areas in question that need to be amended as relate to this local government council fiscal autonomy. For example, section 162 subsection 6 talks of state joint local government account, which envisages a situation whereby the governor of a state, through the apparatus of the state, will hold the money meant for the council for the council. But with the judgment of the Supreme Court, that provision has been rendered odious. It's no longer relevant. And you also see that there appears to be a kind of conflict or contradiction between that section 162 subsection 6 and the provision in section 3, which talks about allocation of the monies to each level of power: the federal, the state, and the local government. And again, you also see that there also appears to be another inconsistency, because if you look at section 167, it says that each state shall pay to local government council in its area of jurisdiction such proportion of the total revenue on such terms and in such manner as may be prescribed by the National Assembly. Then you go to subsection 8. It said that the amount standing to the credit of the local government council shall be distributed among the local government councils of that state on such terms and in such manner as may be prescribed by the House of Assembly of that state. Which one do we follow? The other one says it should be shared, it should be paid to the local government council as prescribed by the National Assembly. Subsection 8 says that it should be paid as prescribed by the State House of Assembly. Also, these are areas of conflict that need to be straightened out. Thank God there's a presently constitutional amendment that is ongoing. They need to look at these things and delete whatever that is not consistent with the clear provisions of the Constitution. You cannot say on the one hand that the disbursement or payment will be as prescribed by the National Assembly, and at the same time go on to provide that it has to be in tandem with the clear provisions of the Constitution, as in subsection 3, and also say that it is as prescribed by the State House of Assembly. I believe that the proper thing is to retain section 162 subsection 3, which says that the money in the federation account shall be distributed into shared into 3: the federal, the state, and the local government, and it should not be made subject to the prescription of the National Assembly, because what the National Assembly is doing with the local government funds, or even the State House of Assembly, what is it doing with the local government funds? We have a federal structure, and now that the money is going to each level of power, then I believe that the Constitution itself has made provision for the functions to be performed by the councils, which before now they have not been able to perform because of lack of funds.
Okay, Barrister Deji,
yes.
what do you think that this recent development portends for the federalism in Nigeria? Because so many people have also argued that this recent judgment is empowering the federal government, especially to strangulate opposition states, the states that are not within the ruling powers, because they now have the power to withhold some of the funds that goes to the state in the guise of the fact that probably they've not done election, or the election was not even peaceful, or because the country is democratically elected. So what do you think? Do you think that there's a merit in the misgivings of some people who are having a kind of not really too enthusiastic about this recent development?
Thank you very much. I think I mentioned earlier on the antithetic provision in section 1625 of the Constitution, which obviously is contrary to section 1623 of the Constitution, because the subsection 5 gives the government or the state the right to distribute, to collect the allocation from the federation account accruing to the local government. And that section will also have to be deleted. As my good friend has said, it's one of the sections that should go, apart from the other section he mentioned, that's subsection 6,
yes,
which has to do with the state joint
section
account.
Section 5, section 6.
5, 6, 7, 8.
Yeah.
All those sections are no longer relevant,
yes,
in view of subsection 3.
Yes.
Okay, now, if you look at the structure of our Constitution, that's why some of us have said the Constitution that we are operating today pretends to be a federal constitution, but in the actual sense of its framework, the legal operations, the legal structure, the geopolitical distribution of power and resources, is a unitary constitution, and that is being borne out by the recent controversy over this judgment. Now, if you look at the structure of that judgment, the judgment looks okay ordinarily on the face of it, but the judgment is giving power to the federal government to deal directly with the local government in terms of fiscal and autonomy. Now the federal government can directly dictate who gets what directly in any local government, and we have about 774 local governments in the country. Now the effect of that is that you have empowered the federal government to determine and dictate how the local government will get their money, and when they get their money, and how they get their money. So, and that is like by cutting the state government. Meanwhile, there are provisions in the Constitution that says also that the state government shall supervise both the fiscal spending and all other issues that relates to the local government council. So you have a conflicting of structure, a geopolitical problem in that. And I think those who are against the decision of the Supreme Court are looking at it from that dimension, from that angle, that if you say that the state is supposed to be under the supervision of the local government, the local government is supposed to be under the supervision of the state, then the federal government has no dealing, should not have any dealing at all with the disbursement or the allocation of monies to the local government council. But again, on the other side, we have a situation in our hands where the governors have not been sincere and honest with the way they handle the funding, the financing of the local government. In my own area, I have once accosted one of my junior brother who is the local government chairman, why he had not been able to carry out projects in his own area. And what he told me was shocking, that he showed me the papers that in a particular month he was supposed to collect 80 million as allocation to his local government, but he was given 10 million by the state governor, and he was made to sign for the entire 80 million, whereas what actually came to the local government was just 10 million, and there was nothing he could do with the 10 million naira. So that has been the situation. So the interplay of politics, the nature of our constitution, as well as the inherent conflicts that are in the provision of the constitution, makes it difficult to know exactly where we are heading to. Yeah. That's why some of us have suggested this document should be jettisoned. Let's have an autonomous constitution that will be federal in nature, that will take care of the geopolitical interests and will structure out all these problems that we're having.
Because I think you raised a valid point. Maybe we will get our guests on Zoom to help us, because we need to understand. You raised a valid point about the supervision of the local government by the state.
I have a view on that.
Okay.
What I think is that those who are saying that the governors or the state governments should supervise local governments, they are trying to make local government to be appendages under the states. But that is not, to me, the clear interpretation of the Constitution. The Constitution says that there are 3 levels of power created: the federal government, the state government, and the local government. They are independent of each other. Now, let's assume that tomorrow the federal government says, well, we want to supervise state governors. Will they agree to that? If they agree, is that the constitutional provision? The answer is no. Now, the Constitution, which is the supreme law of the land, has created 3 levels of power. At the federal level, the federal government; at the state level, the state governments; at the local government level, the local government. And each is to stand on its own. That's what the Constitution has said.
Yeah, but the concern is being that if the federal government will be dealing with this local government, we have 774 local governments across the federation.
I can tell you,
and now that the money is being paid directly to them, we're also talking about the financial management of these funds. It's EFCC that is headquartered in Abuja, being superintended by a federal agency. Is this going to be the agency that is going to supervise the spending of these resources? Or is it the state? Are they not supposed to create their own anti-corruption agency that is closer to this local government? You can imagine the EFCC in Abuja investigating the local government in Borno or Adamawa, that it doesn't understand the operation of that, because these are the concerns.
You see, we are getting closer to where we think things will work well. And what is that? That the way things are in Nigeria today, apart from the federal law enforcement agencies, there's also need for law enforcement agencies at the state level, as well as at the local government level. That is the way it should be. Of course, I'm aware of the calls for state police, which I fully endorse, because the level of insecurity in this country. Now, we don't start off by believing that once the money gets to local government councils, they will mismanage them, they misappropriate them. And of course, even at the state levels, don't they misappropriate funds? So the fact that a local government chairman may not use the funds for the purpose of which it is meant is not enough reason to say, okay, let the governor keep them, because that is what has made the local government council a shadow of what it's supposed to be. It's supposed to be being with activities. You remember in those days when there are transport systems set up by local government councils, they go into farming, they go into a lot of things. The markets, cemeteries and other things, they generate revenue of their own. Radio license, television license, lock-up shops, and those things. They have area there, and there are things they are supposed to do. There are rules that are supposed to be maintained by local government councils. There are rules that you don't wait for state government to go and maintain. There are rules that you don't expect the federal government to go and maintain in rural areas. Whose duty is it to maintain those? Is it local government council? And how can they do if they don't have the funds? So I don't share the views of those that say, let the state supervise what? Let the state do their own creditably, commendably. That's the way it should be. Not that the state will be like the big brother supervising what we have seen over time. Even in some states, they will tell the local government chairman, let us do joint project and so on. In states where the local government is supposed to collect tenement rates.
Okay, let us quickly get Mr. Ajeneko online to let us also get his opinion on. Of course, we talked about financial autonomy. We're also talking about management of resources, because the whole interest of all of this is for the people at the grassroots to benefit the dividends of democracy. So if at the end of the day there are no structural adjustment to ensure that the people at the grassroots, at the local government level, that life comes back to the local government level through this landmark judgment, of course it would have been an effort in futility, because there has to be a structure to ensure that the various local governments use this fund for the purpose in which it is meant for.
You see, I quite align with the gentlemen in the studio. They have spoken well, brilliantly well, in respect of this matter that you have brought up. But then, I want to only chip in this. I want to believe that regarding the section 162 of the Constitution of the Federal Republic of Nigeria, 1919 as amended, we all know that something used to come up when you say the express mention of one thing is to the exclusion of all others. And at times you say, well, yes, there is an exception. I want to say that the Supreme Court was very clear in its judgment in respect of this matter, that autonomy, financial autonomy, should be to the local government areas. Secondly, my learned friends over there have spoken well about the disbursement and usage and monitoring of usage of funds allocated to them by the federal government. And also on the issue of the federal government determining which local government out of the 7 and 74 is due to receive the funds or not due to receive the funds in respect of what they have done or what they have failed to do. I also want to say this, that look, when it comes to the issue of supervision of the local government areas by the state, I say it's a no-go area. One should not encourage the state government, in any state government in any form or in any disguise, to begin to say, yes, you must supervise the spending of the local governments. What are we saying? If there is autonomy, financial autonomy on their part, are they not intelligent enough to know how to apply the funds they have in their custody? By the time you begin to monitor them, then you now put them under the direction of what you want them to do. There will be contracts that will be awarded. You will begin to influence them to award certain contracts at certain sums of money. So perhaps the cronies of the state government, I would say, I won't mention state government, state government. This should not be so. The government has been wise enough, the Supreme Court has been wise enough. Are you there? Are you there?
Yes, go ahead. We'll listen to you. Okay, yes, we can hear you. Go ahead. Yes.
The Supreme Court has been good enough in being very strategic and in mentioning particularly autonomy, financial autonomy. I would say there are several ways. There are many ways that could be devised to ensure that there is transparency in the expenditure of the local government areas. As Barrister Ume mentioned, who are those ones currently supervising the spending or expenditure of the state government? As EFCC or the federal government on its own has an agency that has been monitoring or supervising their spending. They have the independence to spend as they so deem wish, pertaining to the wishes or needs of their states. Now, the local government areas also should not be in any way, hindered or held from doing what is right in respect of what they are doing or to do at the local government areas. You can, yes, that should, in a place where there is no check and balances, then we will begin to have issues. What needs to be put in place should just be a method, perhaps the local government areas reporting to their constituencies on what done, what sum of money collected, the application of the money collected. And everybody will be seen to be transparent enough for anyone, even for the state governments to see. The state government is not even coming up to say to the residents of the state to say, this is what we have, this is what we have spent, this is what we see. They even hide what they collect from the federal government. They don't let the people know. People are wiser. They can get those allocations. Even the federal government is not publishing it, because some of the state government are now saying that they have not getting enough money from the federal government and are therefore unable to do certain projects in their states. The same thing will apply to the local government areas. You only ensure
All right.
that when they do say,
all right,
when they do projects, they're laid before the public.
All right, thank you very much, Barrister Jadeku, for that insightful analysis.